I'd like to welcome everybody, and I'm extremely happy to be joined today by Sheldon Wisener, a criminal lawyer in the GTA since 1986. He's a former director of the Criminal Lawyers Association of Ontario. He's a member of the board of directors of the York Region Law Association and was a part-time assistant Crown from 1999 to 2016. He now also serves on the board of the Alzheimer's Society of York Region. Welcome, Sheldon. Thanks very much for joining us.
Hey, Gary. Nice talking to you today.
Great. So you're going to give us a bit of a sense of what's happening in the criminal justice system in the GTA, including York Region. I understand you did a video appearance, a conference appearance on a criminal matter yesterday, so I wanted to get your thoughts about that experience. But just generally speaking, what is the state of the criminal justice system under COVID?
So, in essence, we're at a standstill. The courts were closed on, I believe it was March 15th. The email went around from various trial coordinators and from the Chief Justice. So, criminal courts are closed with the exception of dealing with new arrests and bail matters. So if a person is arrested today, and the police take them to the court for bail hearing, they will have a bail hearing. And then if they are released, their first appearance in their matter is adjourned automatically to 10 weeks away. If you are already in the system and and you're out of custody, you had a matter coming up, your next court appearance, you don't even have to attend. The administration of the court system is automatically issuing a bench warrant with discretion, meaning they're assuming that you were there, you don't have to be present, and your case is put over for 10 weeks, which is not necessarily a good thing, but it is what it is, given its current circumstances.
And are any of these appearances in person now, or is it all being done by video conference?
So a person who's out of custody who has an ongoing matter just doesn't show up. And there's a justice of the peace or a judge in the court. There might be a court clerk. There's usually, for each different courthouse in Ontario, there's usually one or two Crown attorneys who are attending in person and dealing with the matters administratively. The matter I did yesterday was an in-custody bail hearing, an in-custody guilty plea. And I did that. That was done remotely. It's the first time I've ever done one of those. So in that circumstance, the Crown attorney was working out of her home. I was working out of my home. The judge, His Honorable Justice Scully, was sitting in the court office. He was sitting in a courtroom. Our client was on a video screen, and there was a court clerk. I'm not sure if she was in the courtroom or she was in the court building. The reason I don't know is because my portion was by audio. The Crown attorney's portion was by audio. The judge's and the young man's portion was by video.
That's got to be a bit awkward for you as counsel. That,
well,
the judge has a direct line to your client, and you're not able to view that, assess that, and address that in any way.
So you're very perceptive. It was awkward. Firstly, it's awkward because it's more time consuming than otherwise would happen if we were doing this live. And maybe if we were all on a video feed, it would go a little bit faster. But the nature of the court protocol is the judge does what's called a plea comprehension inquiry. So we asked the young man basically questions like, do you understand what you're charged with? Do you understand that by pleading guilty, you're waiving your right to a trial? Are you doing so voluntarily? I understand there have been some discussions with your lawyer and the Crown attorney. Do you understand that whatever they've decided, it's up to me and I have the final decision? Now, these are things I usually get in writing from my client beforehand. And it's sort of a pro forma thing done in court, and some judges do it just the same. But now in this circumstances, I went through it with my client in a previous phone call. But when the judge was asking these questions, he was just mumbling answers. So it's a bit of a challenge, and it's somewhat frustrating. Ultimately, we completed it and got the job done. And that portion of the case is closed. So that was good. What's happened in a couple of other matters that I've had, where we've had scheduled judicial pretrials, which, as you know, It's a meeting with the Crown Attorney and a judge and a defense lawyer to discuss the future of the case, whether there could be a negotiated settlement or if there's going to be a trial, to figure out what the issues are at trial, how long it's going to take, how many witnesses are required, and so forth. I have done 2 of those. One actually on a murder case, and the judge flat out said, the Crown and to myself, there's nothing we can really do. I don't know when the court's coming back. We've chosen, so the Chief Justice chose June 1st as a target date. So they're adjourning matters into the first week of June and thereafter. In our murder case, the judge said, well, we'll come back on June 2nd and then we'll take it from there. And as much as the Crown Attorney tried to get some indication down the road of where we're going to have sort of target dates because everybody has an interest in making matters go quickly, the judge put a stop to it very quickly, saying, well, ladies and gentlemen, we don't really know where we're going. So, from that point of view, the criminal courts are kind of at a standstill.
Is any of this going to have this delay going to have any implications in view of the Jordan ruling?
So the Jordan ruling is not really going to apply to the actual delay per se. The problem comes, let's be optimistic and say we come back online and the court opens up on June 1st. Well, we've had every single case adjourned to the 1st and 2nd week of June. So if that happens, those are not going to be trial dates. So from then it's going to have to be triaged to later dates. And I think depending on how far down the road things get postponed, that's when the Jordan stuff might be.
Yeah,
It's going to make a lot of work for the Crown Attorney to prioritize what they view as the more serious matters, what they're in danger of potentially losing.
There's going to be a high onus on crowns and the courts to load up trial dates, and I can imagine that's going to have real implications for the civil system, which is probably going to be even further delayed as the criminal system gets priority.
I think so. I think you're absolutely right. I think if you're a petty criminal, side benefit of this is you're probably going to get a nice little 10 Hail Marys and 10 Our Fathers and be on your way, because the court is going to be so backed up, they're not really going to waste time with somebody who's going to break and enter into a garage and stolen, a pair of skis and a basketball. They're going to focus more on the high-profile matters: sex assaults, domestic assaults, impaired driving, crimes of violence, that sort of thing. The difficulty is, because everything is delayed so far, if you happen to be an innocent person and you're sitting in jail waiting a bail hearing, you're in limbo. Jail is not a fun place to be at the best of times, and now as an inmate in a jail, you're exposed to COVID. There really isn't much social distancing in jails. Most jails have people sharing cells.
Certainly, there's lots of reports in the U.S. about serious problems in the jails. Are you hearing anything here?
There have been outbreaks in the jails. They tried, the word leaks out. What they are doing is a lot of people are being released from jail. Enterprising lawyers are trying to go to bat for their clients. If their clients are not charged with the most egregious of offenses and have the wherewithal, funding-wise and surety-wise, to do bail reviews, there are a number of people who are being released with ankle monitors and put on house arrest. There are people who are serving sentences who are approaching the end of their sentences. So within, let's say, 90 days of their statutory release, they are applying for release through a temporary absence program, which is kind of what we would refer to as weekend jail. But essentially, they're put on house arrest and told to go home and stay home. And the officers are calling to check up on them, or they've been given ankle bracelets, some with GPS tracking, some without GPS tracking. So on the one hand, that's a benefit, but I was reading a story in the States actually about 2 days ago where somebody who was released from custody due to the COVID pandemic and concerns in the jails, the day after he was released, he went and shot somebody down. So releasing violent offenders onto the streets is not always an optimal solution if the police force doesn't have the wherewithal to track all of these people, which they don't.
Yeah, well, it's obviously very difficult on all the people involved in the system, including the lawyers and the judges. Just, I wondered if you have any thoughts about video conferencing and the technology changes in terms of filing documents post-COVID. And are we now in a petri dish that's experimenting how these alternate technologies are going to work and perhaps be part of the system permanently?
I think you're right. I think we are in a testing phase. And there is no universal system because the system in place in downtown Toronto is not necessarily the system that's in place in the criminal court in Dryden, Ontario, or the criminal court in L'Original or in Kingston. Everybody seems to have their own little unique facilities. There has been video conferencing in the past number of years, for something called a wash court, which is if a person is arrested on the weekend, and in York Region, where my office is located, usually, quite often the wash court is in Barrie, so everybody is marched up to Barrie, and they appear by a way of a video link to do a bail hearing, but that's a rarity, and that's on the weekends. They implemented in a number of the courts to do bail hearings by with a video link, but that's within the courthouse. The accused person is sitting in a jail cell up in the building, in a different part of the building, and rather than pay the expense of having two officers escort that person down into the courtroom and wait for them, and then escort them back to the cells, they started doing bail hearings remotely within the building. But that, I don't think, was designed to speed up the process, but more to save money on staffing costs for the ministry.
Well,
But
sorry, Sheldon, how do you see this working in the future? Is there a role for certain kinds of procedures like judicial pretrials, as an example? Can they be done just effectively by video, or does in-person really make a difference as far as you're concerned?
I prefer doing my judicial pretrials in person. The reason being, the two that I've done so far by way of conference call, there is no video. So I have no cues as to whether the judge is really buying into what I'm saying, or if the judge is rolling his or her eyes and saying move along with it, if the judge is appearing in any way sympathetic. A lot of what we do is personal connections. It's very hard to have a personal connection over a phone line. Video conferencing is a step up if and when that becomes available.
Well, it is available. I mean, we're doing it right now.
So I agree with you. I really do. But you have to understand, the system is so antiquated. The way they've only switched, the Crown Attorney's Office switched away from VHS tapes about 7 years ago. So on a typical case, I show up on behalf of my client to get what's called disclosure, which is all the evidence that the Crown Attorney is going to be giving. It used to be they would give us a stack of documents. Sometimes that stack of documents was banker's boxes worth of documents, all in paper. Interviews with clients or police interviews were provided by VHS tapes. And I still have a TV VHS player sitting on my secretary's desk. They switched to DVDs about 4 or 5 years ago. Well, guess what? Go buy a new computer. See if you can find a DVD player with it. You can't. You have to buy an external DVD player. So they're so far behind the curve. But moving forward, I think it's a great idea. You know, we have triage courts where there are times that there are 400 and 500 people there, and they are basically waiting for the most of the day to have a 2-minute appearance. And in those 2 minutes, they say their name and they say they want a postponement, or they say why and then they're asked why they want the postponement. Well, I don't have the officer's notes, or I'm missing, my lawyer's not available. These things should be done moving forward, should be done by video conference. There's no reason why.
Yeah, well,
You think of when the dust settles and when we get back to work, in the absence of a vaccine or a treatment protocol, I don't know how many lawyers or how many accused people are going to walk into your typical criminal court building in the GTA, and there's 750 people standing around taking the one elevator that actually works. But one of the bonuses I found in my own little case, the matter that I dealt with yesterday, was material. So in the past, if I wanted to provide a judge with a copy of a psychiatrist's report, a copy of reference letters, I would have to, in advance, provide hard copies. They'd have to be originals. A lot of judges and crown attorneys would not accept photocopies or fax copies. So I'd have to track down original documents, give them to the trial coordinator, who would then provide it to the judge's secretary, who would then make its way up to the judge or to the court clerk. It's so much easier what I dealt with this week in this matter. I had all these reports scanned and emailed to me by the various treatment providers. I emailed them to the judge. The judge said, thank you very much. So he had them in advance of our matter. And I'm sure, in my experience, a lot of judges were very happy not to have to drag home 2 banker's boxes worth of documents, as opposed to seeing an email and reading it on their computer, whether it's in their home office or their work office.
Yeah, I've heard that from judges too. They basically are more than happy to receive things by emails, carry them around on their iPad, and not have to deal with the backbreaking labor of carrying a day's worth of files home. The Chief Justice, Justice Morowitz, made a very strong statement a couple of days ago that was reported in Lawyers Daily, basically that the end of paper has come in the province of Ontario court system. And, you know, I hope that winds up being true. It's a very ambitious statement, but, you know, we talk about access to justice all the time without ever addressing just how much it costs to produce paper and get paper filed in the courthouses in time for hearings. And if we can remove the inertia that's caused simply by paper-related issues, we're going to save a lot of time and a lot of money in the court system. And I hope we can take the Chief Justice at his word that these changes are now going to be implemented rapidly. And again, we've been dealing in Ontario for decades with the reality that there's free off-the-shelf technology like email and Zoom that allows these efficiencies to be brought into action immediately, and for all kinds of reasons, mostly relating to the imperfections and security-related concerns about these technologies, they never come to happen, and the government spends millions of dollars trying to create a better mousetrap that's inevitably obsolete by the time it's complete. So
Yep.
I hope we're now going to start using the technologies that are available. And, you know, while the hearing that you described yesterday might be a step in the right direction, it's only a baby step because the technology, including the technology we're using right now, would certainly put people in better position than sort of a half-baked approach to some people on video, some people on phone, etc. So let's hope this is where we're headed.
I hope so. You know, I used to joke with my buddies and colleagues that if we had $1 for every hour we spent sitting on a hard wooden bench in the courtroom waiting for a case to get called for what's basically a procedural appearance of under 5 minutes, we'd never have to work.
Yeah.
It's.
Do you think that bail hearings can be done effectively by video conference, or is that one of those needs to be in-person kinds of things?
Listen, if people are willing to take a leap on technology, I think everything can be done. But as part of my practice, I also do work for the Office of the Children's Lawyer, representing kids, often in child protection courts. And there are various CAS agencies in the GTA who refuse to use email because they view it as not being secure. So when I will say, I'll send an email to a lawyer saying, can you give me an update on this particular case? I'll get a response back that's heavily redacted and a phone call saying, you know, we can't really use email. So if we continue with that mindset, then I think it'll be 2 generations before we're probably converted to technology, which is probably by then be completely obsolete. But if we want to take a leap of faith and say, you know what, it's an email, we can do pretty much anything we put our minds to. In terms of a bail hearing, if you have the trier of fact, let's say the justice of peace, sitting in a courthouse because he or she's in a central location, you've got a clerk who's managing the paperwork, and managing the various video screens. It's conceivable. You have the accused in one location, defense counsel in another location, crown attorney on a screen, and the witnesses who are there to be examined, like the police officer who's going to testify as to what charges are all about, and the defense lawyer is going to cross-examine the police officer. Is it feasible? Yeah. Is it preferable? No. I think my mindset, I'd rather be there in person to do.
Are there bail hearings that basically go on consent that aren't contested?
Sure, there's tons of bail hearings that are on consent, and those are happening now by way of conference call, not necessarily video. They don't have the technology. So if I had a client who gets arrested, let's say he's charged with some sort of property offense, he has a criminal record, he's taken to court for a bail hearing. There's a duty counsel who is either present in the building or working remotely, who is going to either do the bail hearing, or if I'm appearing, I have to call into a particular number, speak to the crown attorney. We talk about it in advance. We try to negotiate what the terms are. If we can reach an agreement on what the terms of the release are, then the crown attorney notifies the justice of the peace. The hitch is, if the person's being released and a surety has to be present, the surety is still required to show up at the courthouse building and meet with somebody to sign the documents. So we're part of the way there. We're not all the way
there.
there.
When I think of the life of the typical criminal lawyer, I think of you sort of bouncing from bail hearing to bail hearing to bail hearing as a daily adventure, and Newmarket in the morning and Burlington in the afternoon, Toronto somewhere in between, and you got to make it to Brantford at some point also. And that seems to be what criminal lawyers tell me about their days all the time. And it would seem to me that if at least part of that could be done more regularly by video conference without any prejudice to the accused, then that would certainly make everybody's life easier and, again, save a lot of expense for the clients.
And it would be a lot less stressful for the lawyer. So you're not sitting in traffic and racing from point A to point B. Inevitably, something happens at point B that delays the system, and then you're late for your appearance in point C. So when you're young and you're starting out and you're running around like a lunatic because you're trying to, because that's the nature of the game, you do a lot of that. When you get a little bit more seasoned, you try not to, because that stuff takes years off your life. And sometimes it's a lot smarter to stay in one location and have your friends or agents cover for you somewhere else. Because realistically, we can't be in two places at once too many times in a week.
Yeah, but your schedules often call for that.
Yeah.
So,
and criminal law is very fluid. If somebody gets arrested tonight and is in court tomorrow, you have to find a way to drop things and run.
Do you have any different recommendations for clients now who have brushes with the law while COVID is ongoing? What do you tell people now? You get a call, I'm in custody, or the police want me to come in, or they're at my door. What's your advice to people now?
Well, my advice to people hasn't changed in 33 years. My advice to people is, you have a right to remain silent. You really need to use that right. You should be polite to the officer, give them your name and your date of birth and your address if they don't have it, and say, my lawyer has told me to keep silent. I'm not giving you a statement. Thank you very much, officer. I tell people that if the police have you in their crosshairs, they're arresting you, and you're not talking your way out of it. All you're going to do is dig yourself in deeper. Whether the officer comes there and tries to be all friendly and say, well, it's just you and I talking, there's nobody else here. Just, let's just talk us guys. It's no different than the officer who puts a boot on the chair and says, you better tell me what I need to know or else. The net effect is the same. So I tell everybody, shut your mouth.
Shut your mouth.
Shut your mouth. Be polite, shut your mouth, and assert your right to have a lawyer. Speak to your lawyer. If they give you that phone call, call your lawyer. just so it'll calm you down. Your lawyer can tell you on the phone, shut up, don't say anything. If you're asked to blow into a breathalyzer, blow into the breathalyzer. But because decisions down the road are made by crown attorneys and judges. They're not made by police officers. If the policeman is coming to arrest you, you're getting arrested regardless. So there's no value in you trying to tell your side of the story to a police officer because he or she is just recording all of that. And then, well, under COVID, 10 weeks later, your lawyer gets the file and looks at you and says, what did you do? Why would you? You've tied both of my hands behind my back.
Okay, well, that's some sound advice for people out there. Just keep quiet, speak to your lawyer, and let the justice system do its thing.
Yep.
Anything else you can tell us about Wisener Law, the kinds of cases you do, and what you really like to do as a criminal lawyer?
Everybody has their own idea what criminal law is from watching TV shows. I think it's sexy. It's not. The newspaper is full of reports of shootings and murders, but the reality is most of our criminal courts, about a third of it, are drinking and driving offenses. The message really hasn't got out. And actually, impaired by drug too. A third of it is domestic-related assaults. The garden variety stuff you hear on TV, on the 11 o'clock news, the shootings, the drug dealers, all of that kind of wild west stuff is really maybe 20% or 33% of what goes on. So there's a lot of property-related offenses, a lot of sex assaults, a lot of domestic assaults, a lot of driving offenses. That's what the vast majority of work we do.
Anything else you'd like to add? This has been a great conversation. I've learned a lot just hearing about your experiences. Anything else you want to say to the world out there during COVID?
Well, first, I want to thank you very much for having me on. I've never done one of these before. This has been kind of fun.
You're a natural. You belong in front of a camera.
Oh, yeah. As long as I'm not holding a picture with a number in front of it, that's good. But no, I would, my message to everybody would be to basically don't be stupid. Stay home, go out once to go grocery shopping, lay low. We're all in this together. We have to look out for one another as a society. And the quicker we do that, the quicker we get back to normal.
Agree totally. Stay safe, everybody out there. And the world will come back one step at a time over the next couple of months. We're all looking forward to that. But in the meanwhile, just take care of yourselves. And Sheldon, thank you so much for spending your time with us today. Again, great information. And remember, people out there, keep your mouth shut. If the police come to your door, don't say anything. Tell them your lawyer said, I've been advised not to make any statements.
Oh, the other part is if the police come to your door, you don't have to let them in. You shouldn't let them in. Unless they have a warrant, you're not allowed into your house unless they're in hot pursuit of you. So if they come and knock on the door and say, hi, can we have a conversation? I would say to the officer, if you want to back up 6 feet away from me and then go outside, put on your mask, close the door behind you. There's no reason to let them into your house because once you've let them into your house, they can go snooping and doing whatever the hell they want to do. So not give them an opportunity.
I saw a graphic on Twitter this morning. It was a welcome mat outside somebody's door with the words, come back when you have a warrant. So on that note, thanks. We'll speak with you again. Hope you'll come back and talk to us another time, Sheldon.
I would love to. Thanks.